Today's topic will be EU citizenship. This is a very common examinable topic for EU law. That's why I have chosen it. And first of all, we will go through the problem and essay question style, how you should answer problem and essay questions, and then we will focus on a specific question on EU citizenship. As you probably already know, the recommended structure is IRAC, both for problem and essay questions. Firstly, you need to say what you are going to discuss. What is the legal issue if it's a problem question, but do not repeat the facts of the case. I've seen many students understand stating the legal issue as repeating the facts of the case. That is not necessary. You don't need to repeat the facts of the case. In the legal issue is to say what is the legal issue. So, for example, to apply Article 21 of the Citizenship Directive, how Article 21 applies. That can be a legal issue, but reiterating the facts is not a legal issue. The rule is you have to explain the law in this case and apply one by one each principle and comment on it. Then you need to apply and provide analysis. There can be sometimes more than one case that applies and those two cases may suggest a contrasting outcome. Which one you should apply? I suggest you apply both and you say which one is most likely to apply in the given circumstances, depending on which one is more factually relevant, which one is more similar to the given case. So if you are able to distinguish and apply cases to the facts that has been presented to you, that is very advanced legal skills, and that is what usually gets a first class. You don't get this kind of legal skills straight away. This is coming from a lot of practice. So I suggest that you go through past exam papers and answer as many problem and essay questions as you can. Just practice answering them as much as possible. And I suggest that you also get someone to review and give you feedback. At the end of each legal issue, you should have mini conclusions. And well, if you're limited in the exam, so if you have only like 1 hour to answer a question, you don't need to have an overall conclusion. But if it's a coursework, I also suggest that you have an overall conclusion at the end of the problem question that summarizes all the legal issues and your advice to the parties. But if you're very limited in time and you're in a rush, I believe that's just outlining all the legal issues, at least the main ones, applying it to the facts of the case, and having like mini conclusions after each legal issue should be perfectly fine, and you don't need to do anything else. Essay question style is a bit different, but you still need rule and analysis here. Instead of application to the facts of the case, in case of an essay, you need to provide analysis. So you need to first outline the relevant law, which can be, for example, if it's about EU citizenship, it can be the Citizenship Directive. So explain the relevant legal provision, whether it's Article 21 or Article 45. You explain first the treaty on the functioning of the European Union, or whatever treaty you are discussing, or a case law. Then you provide analysis. What does this case law that you just explained mean for the essay? So refer back to the question and answer the question asked. So basically the case that you just mentioned, how does this case answer the question asked? What is the argument here? You should make sure that your arguments are very, very clear, because essay question is not about demonstrating how many cases you know. Even if you put all the right cases there, the applicable cases, but you do not show the relevance of those cases to the essay question, and you do not make arguments, I believe that you won't be able to pass. So just knowing the law is not enough. You should be able to apply the law to the essay question and provide analysis, arguments. Example essay question that you may get in EU law. EU citizenship means equality of opportunities. Nationals of the EU member states have equal access to employment anywhere within the European Union. Critically analyze. So you need to argue for and against. Is this statement true? To what extent? Most of the times they give you controversial issues, which does not have yes or no answer. In law, you never get yes or no answer, but you need to argue both for and against. There are always arguments on both sides. In the introduction, you don't put any arguments. I believe that in the introduction, you only have to explain the relevant law, the relevant legal provisions. In this case, the most important is to explain Article 45 of the TFEU, which is about freedom of movement. And that shall entail the abolition of any discrimination based on nationality between workers of the member states as regards employment, remuneration, and other conditions of work and employment. Basically, this means that any EU citizen can go from one EU country to another EU country and access employment without any discrimination. That's Article 45. Also, Article 20, which is about this EU citizenship, is an important addition to what was previously only Article 45. Every person holding the nationality of the member state shall be a citizen of the Union. It establishes the concept of EU citizenship, which was not present before the Citizenship Directive. Article 21 states that there is a right to move and reside freely within the territory of the member states. Basically, the thesis statement is announcing the plan, and by announcing the plan, we mean that you have to say what your essay is going to argue. In this case, you have to critically analyze if Article 45, 20, and 21 gives equal access to employment opportunities, arguments for and against. Arguments are twofold, as we have mentioned. First, you need to argue that EU citizenship guarantees the equality and free access to employment opportunities. And secondly, you need to argue that EU citizenship does not guarantee the equality and free access to employment opportunities. You need cases and journal articles to support both sides of the argument. If it's a coursework, I suggest that you have peer-reviewed journal articles, because peer-reviewed journal articles are usually very higher quality academic resource, and that gives you higher marks. If it's an exam and you can remember some journal articles, that would be really, really good. But again, it should be relevant. So it's not about just putting journal articles there. It's about making it relevant. So you have to provide relevant journal articles and provide very high quality arguments referring to journal articles and using those journal articles to support your points. I'd like to review the case of Baturis and Kupatanzi. The first paragraph here in this case, the first paragraph of Article 12 prohibits, within the scope of application of the treaty and without prejudice to any provisions contained therein, any discrimination of nationality. Therefore, resident nationals of other member states who have become unemployed after working for a short period of time have the right to receive social assistance benefits. So basically, this case has established that when EU nationals are residing in another member state and they have become unemployed after being in unemployment, they can get benefits. What does this case show? You need to refer back to the case. Does this case show that EU law grants equal employment opportunities? It can be argued that this case does show that, because when after becoming unemployed, if they have access to social assistance benefit that helps them out to stay in the country and find another job, so that it can be argued that in that sense, EU law gives equal opportunities to both the nationals and members and nationals of other member states. Another case that you can use is Peter Bray. EU citizens are required to show that they are not an unreasonable burden on the national assistance system of the host country, whereas there is no such requirement for local citizens. Therefore, EU nationals cannot be discriminated for getting a job. They cannot become an unreasonable burden on the social assistance in case they cannot find a job. So what does this show? This shows that EU nationals do not have equal rights, but this does not necessarily show that they do not have equal rights to accessing employment. They just do not have equal rights to getting benefits. You should have a look at the cases of Ray, Dano, Ali Manovich, and Garcia Nieto, where CJEU has become less generous and flexible than it was in Bray, about issues such as welfare benefits for non-economically active EU citizens. You should explain the key TFEU provisions in more detail and interpret if it guarantees equal access to opportunities. Article 20 says that every person holding a nationality of an EU nationality is a citizen and has a right to move and reside freely within the territory of the member state, the right to vote in elections to the European Parliament, and right to enjoy the protection of diplomatic and consular authorities. So you need to interpret what does Article 20 mean for the purposes of the question asked. Does this guarantee that everyone has equal rights? Well, the way the article is drafted, it's clearly guaranteeing that every national within the European Union has equal right to accessing employment opportunities. So yes, Article 20 does give equal opportunities to everyone to access employment. But the controversy is when you look at the cases, because not always that is the case. So basically, you need to show that Article 45 and 20 has been a huge step towards eliminating any discrimination towards EU nationals when they access employment opportunities elsewhere. However, some cases have shown that they are not always treated equally. This case is also important. Martinez Sala, a national of a member state lawfully residing in the territory of another member state, comes within the scope of rationale and the provision of the Treaty on European Citizenship and can rely on the rights laid down by the treaty, which Article 8 attaches to the status of the citizen of the Union, including the right laid down in Article 6 not to suffer discrimination on the grounds of nationality. So this case has confirmed that EU nationals should not be suffering discrimination on the grounds of nationality within the scope of the Treaty on the Functioning of the European Union. Community law precludes a member state from requiring nationals of other member states authorized to reside in its territory produce a formal residence permit issued by the national authorities in order to receive a child raising allowance. Well, child raising allowance is not an issue here because it's not asking about it's not about employment opportunities. Also, non-discrimination of workers. Right to equal treatment and non-discrimination on the grounds of nationality comes from Article 18 and the application and interpretation of its scope by the CJEU. Therefore, even non-discrimination of workers provision is in the Treaty on the Functioning of the European Union, Article 18. It should be mentioned there. Citizens' Rights Directive 2004/38 is also an important legal issue. European Parliament and Council Directive 2004/38 of 29th of April 2004 contains the rights of citizens of the Union and their family members to move and reside freely within the territory of the member states. This directive consolidated all the existing legislation on the free movement of persons into a single document. So this extends the rights to not just the EU nationals, but also to the family members who can freely reside in any member state and have access to employment. You could also have a look at the key changes in the CRD and argue that even though there were some inequalities before the enactment of this directive has addressed those inequalities, and now all the nationals of the member state have equal treatment. Dano case is important because it departed from the previous case law. The previous case law has shown a more liberal approach and more confirmed on every occasion that EU nationals are equal and have equal rights as the local nationals. Whereas in Dano, they have departed from that mainstream approach. Dano was a national from Romania, I believe, but she lived in Germany for almost 5 years. But she was not integrated in society because she had never worked, and she didn't speak the language. There was no chance, no reasonable opportunity for her to get employment, because after being unemployed for so many years, it was unlikely for her to get employment. Therefore, it was argued that Dano could support the argument that it was a step back for freedom of movement rights, showing that the EU Citizenship Directive has not added anything substantial to the Article 45. Basically, her residence permit was revoked in this case, even though she has been living in Germany for so many years, but German government argued that she was asking for benefits, and German government argued that she has become burden on the society and she could not get benefits. This case could support the arguments that freedom of movement rights under the EU Citizenship Directive has not really increased after Article 45. Therefore, Article 20 has not added any additional substantial rights to what we had before under Article 45. In conclusion, you need to sum up all your main arguments in any essay question as well as this one and answer the question asked. No new arguments should be in the conclusion. Conclusion should be just a summary of the main points, and it should not be more than 10% of the entire assignment. I suggest that you have a look at our notes, essay examples, quizzes, tutorial videos, flashcards, and cases for more information. Before you go, I'd like to give you a quick overview of how we can help. Our content creators and tutors are successful law graduates who achieved Title I and first-class degrees from different universities of England, such as LSE, City University, BPP, Kiel University. We're not associated with these universities, but we do hire their best graduates to create content and to deliver tutoring services. In addition to the ready-to-go first-class materials that we have on our platform, we have one-to-one tutoring support that to help you with coursework and preparation for exams. How do we help with coursework specifically? We help students learn how to do legal research, because that's a very important legal skill, and a lot of students are struggling with that. We help students identify the relevant arguments, where to find them, how to find them, structure, proofreading, everything that is important to know for getting a first class in a coursework. We can help you with that. Also, we can help you prepare for an exam. We help you create a revision and practice plan to maximize your chances of getting a first class. We help you practice answering questions, problem questions, and essay questions from past exam papers. We teach you how to do legal research, IRAC structure, and argument making. We have helped thousands of our students already to get high grades, and you can see our reviews. If you'd like to be our next student to get high grades, please join SimpleStudying now. Thank you very much for your time.